Hello, everyone. My name is Katie O'Connor, and I'm Senior Counsel at Demand Justice. Thank you all so much for taking some time to join us this evening to talk about LGBTQ equality and the Supreme Court. I want to start out by thanking our amazing co sponsors, the ACLU of Michigan, Center for Popular Democracy, Lambda Legal, National Center for Transgender Equality, and the National Women's Law Center. I'm also delighted that we're joined by Congressman Jerry Nadler, Chair of the House Judiciary Committee and Vice Chair and founding member of the House LGBTQ Equality Caucus. We truly couldn't ask for better company in this fight. Tonight, we'll hear about a set of 3 cases that are currently before the Supreme Court that threaten to strip LGBTQ people of protections against discrimination at work. Despite significant progress toward equal protection for LGBTQ Americans, 29 states still don't have laws prohibiting employment discrimination on the basis of sexual orientation and gender identity. That means that over half of LGBTQ workers rely exclusively on the Federal Civil Rights Act to protect them. Numerous federal courts have agreed that this existing federal law protects LGBTQ people. But any day now, the Supreme Court could issue its decision in the set of cases that challenge that protection. If the court rules that federal law doesn't prohibit discrimination on the basis of sexual orientation or gender identity, millions of LGBTQ workers could have to go to work every day knowing they could be fired for who they are or who they love. This is not what the American people want. A significant majority of Americans believe that LGBTQ people deserve protection against discrimination at work. Yet this is one in a laundry list of cases this year that could put the 5-justice conservative majority of the Supreme Court against the solid majority of Americans. The court's also going to decide, for example, whether the Trump administration can end the DACA program and put hundreds of thousands of people at risk of deportation, even though the program is wildly popular among Americans of all political stripes. The court's also considering the constitutionality of yet another abortion restriction, like so many we've seen in the past, even though a majority of Americans consistently express support for the right to choose. And of course, the court is going to decide whether New York prosecutors and congressional committees can exercise oversight over the first president in modern history to withhold his financial records from the American public while refusing to divest from his countless business dealings, even though most Americans still say we deserve to see the tax returns. This is a Supreme Court that's becoming increasingly out of step with the American public, and it's become so by design. The 2 most recently appointed justices owe their seats to a bare Republican Senate majority that abandoned all the norms of the institution in order to amass more political power on the nation's highest court. This new conservative Supreme Court majority was installed to do the bidding of the Republican Party. Now they have to decide whether to follow through, and the livelihoods of millions of LGBTQ people hang in the balance. Here to kick us off for this important conversation on these important issues is Congressman Jerry Nadler. Congressman Nadler represents New York's 10th congressional district and is a steadfast ally to our community. He's been an original co-sponsor of every major piece of LGBTQ civil rights legislation for the past 20 plus years. And of course, he's a vocal supporter of the Equality Act, which our panelists will talk about later this evening. He's also leading the fight to demand the documents that were withheld from the public during Justice Kavanaugh's sham confirmation process in 2018. And we're thankful for him for his continuing work to get the answers we all deserve. Welcome, Congressman Nadler.
Well, thank you very much for having me here today to join you for this important digital roundtable to discuss 3 critical cases before the Supreme Court: Altitude Express versus Zarda, Bostock versus Clayton County, and RG&GR Harris Funeral Homes versus EEOC. Any day now, and certainly before the end of June, the Supreme Court will issue its ruling in these cases, deciding whether or not Title VII of the Civil Rights Act of 1964 covers the LGBTQ community and prohibits employment discrimination based on gender identity and sexual orientation. Depending on the court's decision, these cases will either mark a critical moment in the advancement of LGBTQ equality or a shameful example of the court weakening our nation's civil rights laws. Over the past century, the movement for LGBTQ equality has seen tremendous progress from the passage of federal hate crime protections and the repeal of Don't Ask, Don't Tell, to the Supreme Court's ruling establishing marriage equality as the law of the land in the Obergefell case. And perhaps most importantly, the increased ability of LGBTQ people to live their lives authentically and proud. As a member of Congress whose district encompasses the Stonewall Inn, and who now serves as chairman of the Judiciary Committee, I am proud to have played a part in moving our country's laws forward for the advancement of LGBTQ equality. But the reason we have made as much progress as we have is because of LGBTQ people, like many of those listening to this event right now, who have taken the brave step, despite discrimination and lack of acceptance, to live their lives authentically and openly, and to change hearts and minds among their families, their friends, and their communities. I'd like to highlight one of these individuals today, Amy Stevens, a former funeral director who was fired from her job in 2013 after she announced to her colleagues that she was transgender and would be living her life as the woman she knew she was. After she was fired, Amy fought back, filed a complaint with the Equal Employment Opportunity Commission, and sued the funeral home. Now her case, RG and GR Harris Funeral Homes versus EEOC, is one of the cases we are waiting for the Supreme Court to rule on. Sadly, Amy passed away earlier this month. She was a hero in the fight for transgender equality and exemplified what it means to fight for our nation's promise of equality for all, a promise we made 240 years ago and are still far from fulfilling. In fact, much of the history of the United States has been about expanding the definition of who is understood to be included when the Declaration of Independence says, quote, all men are created equal, unquote. When these words were first written, that phrase certainly did not include Black and Latino men. It did not include Native Americans. It did not include any women, and it certainly did not include LGBTQ individuals. People like Amy, as well as Don Zarda and Gerald Bostock, the plaintiffs in the other two Title VII Supreme Court cases, have played critical roles over the years in expanding this definition of who is created equal. At this moment, the Supreme Court has an opportunity to continue our march toward justice, to make clear that our nation's civil rights laws protect the LGBTQ community, and to ensure that they can participate in key areas of life, and to provide them recourse in the face of discrimination. I hope the Supreme Court will issue the right decision. The stakes are enormous, but I want people to know, while the court may incorrectly rule against us on an interpretation of law, and given this court it may very well, they cannot issue a ruling on the dignity that we know LGBTQ people deserve. As a lawyer, as vice chair of the LGBTQ Equality Caucus, and as chairman of the Judiciary Committee of the House, I have studied this issue closely, and it's clear to me that sexual orientation and gender identity discriminations are forms of sex discrimination that should be prohibited under Title VII's prohibition on sex discrimination in employment. It would be unfathomable to me for the Supreme Court to rip away non-discrimination protections for the LGBTQ community, especially in the middle of a national pandemic. But unfortunately, we have seen this Supreme Court do the unfathomable before, such as when they gutted the Voting Rights Act of 1965 in their decision in Shelby County versus Holder a few years ago. But no matter how the Supreme Court rules, we know our work fighting for equality isn't done. If the Supreme Court rules the wrong way, if it rules that Title VII does not protect LGBTQ people, our work will be that much more urgent. But even if the Supreme Court affirms that gender identity and sexual orientation discrimination are prohibited by Title VII, LGBTQ people would still lack protections in other key areas of life where there is no federal prohibition on sex discrimination, such as in public spaces and services and in federally funded programs. And of course, as we've seen in the current debate over reproductive justice, Supreme Court rulings can be weakened or overturned by other rulings down the road. That's why it is critical that Congress pass and the President sign into law explicit protections for LGBTQ people in all key areas of life. I am proud to have overseen the first hearing, the first committee markup, and House passage of the Equality Act a few months ago, legislation that would provide for explicit protections for LGBTQ people, as well as women in places that they are currently carved out of our civil rights laws. Now, we're realistic. We passed this bill in the House. It was my privilege as chairman of the Judiciary Committee to hold the first hearings on this subject in generations. and to be able to direct the committee to report out the bill and to manage the floor debate in which the House approved the bill. But we have a Republican Senate and a president named Trump. It is unlikely this bill will pass into law this year, but next year, God willing, this bill should pass into law if things go well in November. And again, it is even more vital that it do so if the Supreme Court rules the wrong way, but it's very important even if the Supreme Court rules the right way in these three cases. Just a couple of weeks ago, we celebrated the 1-year anniversary of the House passing this bill. It's a disgrace that Majority Leader McConnell has refused to bring up this bill for a vote in the Senate. But let us hope the Supreme Court will, in the meantime, make it clear that the LGBT community is protected under Title VII. But either way, we have our work cut out for us. We have to pass this bill. Hopefully, the Supreme Court will do the right thing and go further along the right direction, but not far enough. If the Supreme Court does the wrong thing, as it may very well do, it just makes our action even more vital. But we will do it, and we must persevere. Thank you all again for inviting me to share these remarks at this roundtable, and for all that you do to fight for LGBTQ equality and justice. I look forward to today's conversation.
Thank you so much, Congressman Nadler. We are truly grateful for your ongoing leadership in this fight. And now it's my delight to introduce our moderator for this evening's discussion. Mark Joseph Stern is a Slate staff writer and a Supreme Court correspondent. He is the author of American Justice 2019, The Roberts Court Arrives, published by the University of Pennsylvania Press. Welcome, Mark. Thanks so much for being here with us tonight.
Thank you so much, Katie, and thank you to our panelists and our viewers. For those of you watching at home, which I hope is all of you, there is a Q&A button on the screen. You should feel welcome to tap it and put your question in. We will save a few minutes at the end of our conversation for questions. Please limit yourself to one question per person, and please ensure your question is on topic, and also that it's a question and not a graduate thesis. So now it is my pleasure to introduce our panelists, some of whom I have served on many panels with, some of whom are new to me, but already feel like old friends. I will start with Rodrigo Heng-Lehtinen, who is the Deputy Executive Director for Policy and Action at the National Center for Transgender Equality. He previously worked with Freedom for All Americans, GLAAD, the Transgender Law Center, Gender Justice LA, and the National LGBTQ Task Force. I would not have wanted to edit your resume, Rodrigo. Rodrigo recently co-led the successful campaign to update New Hampshire's non-discrimination protections to include transgender people, which I believe passed a Republican-controlled state legislature. Is that right? Incredible. Welcome, Rodrigo. Next, we have Sharon McGowan, who is the Chief Strategy Officer and Legal Director of Lambda Legal. She oversees Lambda's efforts to resist any attempt by the Trump administration or any other opponent of LGBTQ equality to thwart or roll back our community's progress toward full, formal, and lived equality. Sharon previously served as the Principal Deputy Chief of the Appellate Section of the Civil Rights Division in the Department of Justice. Welcome, Sharon. I can't imagine why you aren't still at DOJ. Next, we move to Sunu Shandy, who is the legal director of the National Women's Law Center. She helped to create the center's legal network for gender equity and build the policies and procedures guiding the Time's Up Legal Defense Fund, which you may have heard of. Until August 2017, Sunu served as the deputy director for the Civil Rights Division with the US Department of Health and Human Services. Again, so curious that you departed. She previously worked as an attorney at the Equal Employment Opportunity Commission for 15 years. Welcome, Sunu. And last but certainly not least, we have Jay Kaplan of Michigan, which I'm told is under total totalitarian rule now by a petty dictator and tyrant. So I hope you're able to spare your own life in this mad takeover of the states. Jay has been the staff attorney for the ACLU of Michigan's LGBT project since its founding in 2001. He fought Michigan's constitutional amendment prohibiting same-sex couples from marrying, and recently advocated for a transgender high school student who wished to run for prom court. Jay was honored with the 2006 Unsung Hero Award from the Michigan State Bar, but we are all going to be singing his praises tonight. So welcome to all of you. And I'm going to kick things off with a question that people have been asking me a lot lately, and I feel like I answer differently every time. So I'm very interested to pose it to you and then steal your answers. The question is pretty simple. What is your prediction for the outcome of the two Title VII issues before the Supreme Court now? 3 cases that present 2 questions: whether Title VII of the Civil Rights Act prohibits discrimination on the basis of sexual orientation and gender identity within its prohibition of discrimination because of sex. And Sharon, I'm going to start with you because you've always been my glass half full kind of panelist. And when it's beyond 8 p.m. on a Tuesday in 2020, I really need as much glass half full as I can get.
Well, I hope some of you are having a glass of something for this great conversation. Thank you so much. And I want to thank Chairman Nadler for kicking us off, but also to really thank him for starting off this evening by acknowledging Amy Stevens. It's so important for us to remember that these cases are about real people and real acts of discrimination that potentially devastate lives, devastate families. And Amy is no longer with us, but we fight on in her memory. Her wife, Donna, continues the fight with her friends and family at the ACLU, and many of us here who are part of that extended family. So I just wanted to acknowledge that before we talk about, sort of the chess match that we're all waiting to see how it plays out. And you're right, I am a glass half full kind of gal. You can't really do civil rights work without sort of, thinking about that whole bending of the arc. And I think it's interesting because I wonder if we would have the same thought process going on right now if the court had argued the case under the current environment. For example, this past May, where all of the justices need to weigh in with questions, as opposed to the kind of argument that we had in the fall, where there was the typical, some people weighed in and they bantered with each other, and others sort of stayed kind of cards closer to the chest. But look, I continue to think that this is and should be a straightforward textualist interpretation that should be right in the sweet spot of someone like a Justice Gorsuch and those people who want to sort of be in the Justice Gorsuch world, whether that's the Chief Justice, whether that's Justice Kavanaugh. So we could very easily see a world that this is not a 5-4 decision. We could see a 6-3 decision. And really the only thing that happened in the course of the argument that cast some doubt on whether or not the textualist argument would carry the day was a very non-textualist question from Justice Gorsuch, where after going through this series of back and forth, talking about the fact that the statute very clearly seems to cover it within its plain terms, we then pivoted to this question about massive social upheaval. And that's not really kind of in the playbook of strict textualists. So, and the other thing I think it's important to note is that whatever massive social people are afraid of, that parade went through town decades ago. Transgender people are working, LGBT people are experiencing sort of equality in the workplace. This is really, I think in many ways, a fear-mongering question around transgender people. And I think that at the end of the day, as Congressman Nadler said, I hope and continue to think that the clearest path forward is one that vindicates the rights of the LGBT workers. But again, it's important to remember that if they get this wrong, this is a matter of statutory interpretation. You will be sure that we will be back in there to fix it if they do get it wrong.
All right, thank you. Let's move on to Sunu.
Hi, everyone. Thanks so much for including the National Women's Law Center in this conversation. As we say, LGBTQ rights is women's rights. And so we have to be part of this movement, and we are part of this movement. I have 2 thoughts. One is that the court has a choice of rolling back decades of precedent, right? Even before Price Waterhouse, the court said making decisions based on sex stereotyping about if you have kids, you can't do this job, or if you're a woman or you're a mother. There are all these cases about sex stereotyping that say if you make a decision based on a stereotype about a particular sex, that's discrimination, and employers are not allowed to do that. So that's clear. Then you have Price Waterhouse that says if you discriminate based on someone how they talk, how they walk, how they present themselves, that's discrimination based on sex. So you basically can say that decades of precedent will be rolled back in the name of excluding LGBTQ folks, or you can rule for the workers here. So the only way I see sort of a negative outcome potentially is if there is some really unhelpful, mushy decision that will be completely impractical, that where courts and employers are like, what do you do with this? Because how else do you say that if a quote unquote person who you think is straight is discriminated against based on how she presents herself, that's illegal. But if that person is gay or transgender, you don't get those same protections. So if there's any sort of logic to the decisions here, it should be the workers win. Obviously, as we've seen, this, the federal government has switched positions. So clearly this is not about following the law. This is not about the statute. If there's going to be a decision based on the social upheaval fears and all of that, then we'll lose. But if this is about following the law, if this is about following precedent, if this is about deciding in line with workers' rights as it's been, analyzed for decades, then the workers should win.
Okay, Jay, let's get your thoughts.
Hi, everybody. I get the same perceptions that Sharon had. We both were sitting in the Supreme Court listening to the argument, and I think clearly the rationale behind Amy's firing was because of sex, because her employer would not accept the fact of her gender identity and her gender expression. And just based on the comments that he made, why he ended her employment. He was concerned how she was going to present herself, and he felt because of her sex that was assigned at birth that she should not be able to do so. And I was heartened by the comments made by Justice Gorsuch. He said, yeah, it really does sound like it is discrimination because of sex. And as far as the social upheaval, absolutely. For decades, federal courts have been deciding in terms of, based on gender stereotyping, certainly. And then recently, in Amy's case in the Sixth Circuit, they made it very clear that transgender status in and of itself, discrimination on that basis is sex discrimination. And I haven't got to know Amy very well. And after the argument, she even felt, that was hopeful, the comment made by Justice Gorsuch. And she had the similar thought that, if we're not successful in this case, we keep on fighting. We keep on working towards this.
Rodrigo, any thoughts here?
Well, I absolutely agree with my co-panelists, and I'm also optimistic about this. The only thing I have really to add is not really from a legal perspective, but from more just what this means for everyday transgender people in particular. Where a lot of times when we think about being LGBT in the workplace, and especially when we think about being transgender in the workplace, there's a lot of focus placed on the coming out moment, including with Amy Stevens' case. It was when she came out as trans. And I think one thing that's useful for us to keep in mind is that for transgender people in particular, and also for other LGBT non-trans people, there's a way in which you are outed as transgender, especially later on, even after you've come out. A lot of people don't realize that it is very difficult to update your identity documents, whether that's your driver's license or your birth certificate or any social security card. And these are all the kinds of IDs that you are, in most cases, required to show when you start a new job. So when you're trans, it's not just that moment of where you're working a job and you come out as trans, you're transitioning, then your employer knows. It's also, this could be decades after the fact, after your transition, you're starting a new job and your identity documents force you to reveal the fact that you happen to be trans. Even if your employer is supportive enough that they're not asking any invasive questions and you've already transitioned and you're already living life as your authentic gender, these identity documents can still sometimes out you decades after the fact. So I think that's really important for us to keep in mind as we think about what's at stake here. Just the thinking through the ramifications of this. I'm also hopeful that we'll get a positive outcome here, but to put it in perspective of just how important this is, if we do end up losing these protections that we've had for so long, and employers get the message from the Supreme Court that actually now it is okay to refuse to hire someone or to fire them simply because of who they are or who they love, then transgender people, especially those of us who haven't been able to update our identity documents, could very well be in a position where we're hired to do a job. We show up on day one, turn in our HR paperwork, and boom, lose the job just like that because the identity documents revealed what is really just medical information. It should be private medical information between you and your doctor, but these documents are forcing you out. So I'm hopeful we'll get a good outcome, but I think that just kind of puts in perspective just how much is at stake here.
Yeah, absolutely. Thank you for all of that. I think you all did a wonderful job outlining just how high the stakes are, which makes me even more anxious than I was before. But I think that's the appropriate amount of anxiety. Sunu, I want to go back to you because like Rodrigo, you talked about some of the potential ramifications of a bad decision, a decision narrowing Title VII, not just for the plaintiffs and not even necessarily just for LGBTQ people, but what happens if the court makes a total mess of Title VII. And I read some of the briefs in these cases, which claimed that Title VII doesn't talk about sexual orientation or gender identity, so it can't possibly speak to them. I found that curious because other words that don't appear in Title VII are sexual harassment. And of course, the Congress that passed Title VII in 1964 didn't really think through what it would do regarding sexual harassment. In fact, they didn't even have the ability to really conceive of sexual harassment. Most of them were probably sexually harassing their secretaries at the time. Not to slander the entire 1964 Congress, but we've all seen Mad Men. I'm curious if you're worried about some of these other precedents, like the sexual harassment precedent, Meritor Savings Bank, and if you think that a bad decision here could end up doing a lot of damage to not just LGBTQ people, but to the entire edifice of our civil rights law.
Yes, absolutely. There's so much at stake, and I think for women who are gender nonconforming, whether or not they are gay, lesbian, or trans, they will be facing more discrimination if the workers lose here. And that's because employers, if they're emboldened to discriminate and basically think that sex stereotyping is now okay, the people who are sort of least gender conforming are the ones, as usual, will have most to lose. And so these are cases that impact on women's rights inside and outside of the LGBTQ community. And to your point about how case law evolves, you're absolutely right. Sexual harassment, same-sex harassment, pregnancy, there were all these kinds of sex discrimination that may or may not have been contemplated there. But that's why, as Gorsuch said, if you look at this text and sex discrimination is there, are you really telling me that you can think about sexual orientation discrimination, gender identity discrimination completely separate from sex? And that is not possible. It's analytically impossible. And so that is why these justices need to keep that in mind. Also, the way that employment discrimination law works in this context is that the illegal motive can't be part of the picture. So even if you think this is about sex and sexual orientation, sex and gender identity, if sex is part of the picture and that's part of the decision making, then the employee should win here. So for all these reasons, I think we need to keep to the forefront who will be harmed here. It's folks who are gender nonconforming, no matter their sexual orientation and gender identity, and that cuts across all the spectrum. I mean, think about Ann Hopkins, think about Price Waterhouse, right? Her sexual orientation really has nothing to do with that case. It's about how she presented herself. She did not live up to the stereotypes and assumptions that her employer required. And that's the same issue at stake in these cases.
You know, we keep going back to this comment Justice Gorsuch made at arguments, which I agree was so heartening, where he basically said, if you only look at the text, I'm with you. But then, of course, he made the comment that we're all too familiar with about massive social upheaval. And not to dig too deep into the tea leaves, but Sharon, could you give us your read on that comment and whether you think that this was an effort by Justice Gorsuch to seem cryptic and draw headlines, whether you think this is at all a merited concern if you're a judge, and where you think the justice might have been going with that?
Yeah, that's a great question. And I think we probably won't really know until we see how it plays out in the opinions. And I do think in some ways, this was, the court had the case in front of them, but there were other issues that they were clearly already sort of thinking down the road about, right? This was a case where Amy Stevens was fired for coming out as who she was. And immediately the other side went to their old tropes about restrooms and locker rooms. And the first thing out of the gate was something, a hypothetical about a trans woman in a domestic violence shelter. And I mean, they immediately try to go to what they think is the scariest possible place they can go. And it's because they can't take solace in the statute. All they need to do, all they can do is to play into fears about who transgender people are. And I think that is one of the really important things that came out of the decision, came out of the argument, and obviously will come out of the decision, that either way, I hope that we will have a good ruling. There will be a lot left still to work out in the courts, in the legislature. Another really important reason why the Equality Act is so important, because there are these other questions that I think will still be lingering out there. And even our friends on the court, I think, demonstrated that they are still on a learning curve about who transgender people are, which I think is one of the things that makes this case so interesting, or these cases so interesting, is that in many ways, the analytical question about whether or not transgender people are covered by sex discrimination law was much more firmly settled, right? There wasn't a split in the courts. There wasn't some confusion that the Supreme Court needed to resolve when they decided to take this case. But yet perhaps familiarity with trans people is not where it is with respect to LGBT people. And yet on the LGBT side, we had decades of case law that we were only finally reversing through a number of cases that Lambda Legal was very proud to be a part of, including the Kim Hively case out of the Seventh Circuit that brought sexual orientation protections to Indiana, which only can get it through the federal law as opposed to a state law, which they do not have. And yet, you have a place where analytically, it was swimming more against the tide. And yet I think there's obviously sort of more social comfort around the notion of LGBT people being able to sort of access non-discrimination protections. So it becomes one of these interesting places where the analytical side of things doesn't necessarily line up with sort of the social side of things. But in some ways, the Department of Justice, showed their hand by just trying to take it all out, right? There's no distinction in their mind. They want to take all of our rights out. And so we need to make sure that as we think about this work, we understand the ways in which sex discrimination really does sort of impact the entire LGBT community, and that LGBT people have as much investment in making sure that the fear mongering around our trans brothers and sisters does not actually sort of gain hold, and making sure that and again, so important that advocates in the women's rights community understand sort of what is at stake, so that they are there adding their voice to the chorus as well, beating back the fear mongering that is often done in women's name.
Right. So speaking of that fear mongering, Jay, I saw you shaking your head vigorously at Sharon's comments about some of the justices' questions regarding bathrooms, homeless shelters. I know that you were Amy Stevens' counsel for a very long time. I'm wondering how you sort of confronted and dealt with this judicial unfamiliarity or even judicial hostility toward transgender people, starting from the very beginning. This must have been an issue that at the same time you were trying to persuade courts about the law, you're trying to educate them about human beings, right?
Absolutely. And I think the best way for educating was for Amy to tell her story and how it really impacted her life. And I think so many people could relate to it. You had a job that meant so much to you. Her working at the funeral home was something she wanted to do most of her life. She really wanted to help families. She was very proud of the work that she did. It meant a lot to her. And to lose that job, as Sharon mentioned, these are real people. It was devastating to her because it certainly wasn't about her job performance. It was all about who she was, her being her authentic self and saying, I'm a transgender woman. and also the devastating economic consequences that she experienced as a result of losing her job and not being able to get a job in the similar field because of who she was. And then, of course, that had an impact. In terms of on her health as well. But telling her story that all people can relate to. This wasn't about Amy, in terms that there was never a discussion about restrooms. I think it was single user restrooms in the funeral home. So that wasn't an issue. There was never a discussion about, what kind of clothing she would wear. Certainly there wasn't I know Justice Alito brought up the issue of sports, transgender people playing in sports, so it clearly was not the issue that was before this court. But I think the best way that we can educate the court as well as society is for people to tell their stories. And I think many people could relate to Amy's story. And I know it had her being able to be the face of this case and to talk about her experience as a way not only to right a wrong that was done to her, but to help other people meant so much to her. So in essence, her main purpose in her job was taken away from her. But I think she found another purpose in the last years of her life to be the face of transgender rights and to be part of this fight. It was very, very meaningful to her.
Well, I'm glad that we can honor her memory tonight. I'm very sorry that she's no longer with us. And I'm very glad that she will not be the last person to fight for trans equality, and that we are all here to sort of pick up the mantle. And speaking of sort of the broad array of trans equality, not just legal trans equality, but lived experiences. Rodrigo, you were speaking so eloquently about this before, about the issue of identity documents. And I know that there's a lot of litigation. There's been a fair amount of litigation in the States about identity documents. It sort of raises rather fundamental issues about trans rights and trans equality. I was wondering if you could sort of bring us out a little bit further from Title VII specifically and talk about what you're facing in the lower courts as you come with these other claims that move beyond sort of strict statutory interpretation and deal a little bit more broadly with the equal dignity of transgender Americans.
Sure, we're seeing transgender rights be litigated so much more than ever before. And I think it speaks to, as co-panelists were saying, about the growing familiarity with transgender people. It was not that long ago that our issues were so stigmatized that it was almost kind of taken for granted that we didn't have any rights, and that's terrible. And now where more and more of us are coming out, and our neighbors and our families and our friends are finding that, oh, you know what, this is the same person who I've always loved. That transgender people we're trying to maintain and secure our Title VII rights here, because you know what, we're trying to get up in the morning, go to work, and provide for our families just like anybody else. This is really a bread and butter issue. I mean, the ability to get a paycheck and take care of your kids, take care of your loved ones. There is nothing more bread and butter, simple and understandable than that. But you're right, we're seeing now, so with this growing acceptance, we're also seeing a lot of backlash at the same time. Those people who are opponents of all LGBTQ people are really focusing in on our transgender community with a laser focus to try to turn us into a wedge issue and attack all sorts of people, almost using transgender rights as a Trojan horse to go after women's rights, LGBTQ rights more broadly, to really chip away at all sorts of progress that we have made recently. So on some other issues facing transgender people, we're seeing identity documents, as you mentioned, be litigated. For example, this last state legislative session, before many state legislatures shut down due to the coronavirus public health crisis, we saw multiple bills attacking transgender people's ability to update our identity documents, especially birth certificates. You see this the most with birth certificates because birth certificates are sort of tethered to the state that you were born in. So even if you move somewhere else, you are still tied, that particular document is tied to where you were born. So before coronavirus shut so many sessions down in the States, we saw Idaho pass a bill that specifically went after transgender people's ability to update birth certificates. rights. I mean, they're really getting creative. Our opposition is getting creative and trying to chip away at every opportunity they have. That is now being litigated, and big props to Lambda Legal for pushing back on that. It's a really important case that's going to set a lot of precedent, hopefully elsewhere. But it's notable that no state legislature had passed a bill like this since the 1970s. So this is really a resurgence. They're going after us, trying to take advantage of the growing acceptance that otherwise we're experiencing elsewhere. And I think all of this shows just how much we have to go even beyond employment protections. Even if we win, tens across the board, win in every way, shape, or form in the Title VII SCOTUS cases, we will still need the Equality Act. Well, these cases only deal with employment, and other attorneys, I'm not an attorney, so other attorneys on this webinar would be able to explain more about the other ramifications that a win would have in housing and other areas like this. But it is unequivocal that we would still need the Equality Act to secure our protections in public accommodations, which really means just public spaces, secure protections in federally funded programs. So as important as these cases are, there's still a lot more to do, even if we get a total and complete win here. Identity documents is an area, public spaces is an area, federally funded programs and jury service is an area. There's so much more to do even beyond employment.
And one of those things, I think, unfortunately, is to defend some wins that may not stay won, as some civil rights advocates put it. And Sunu, I was hoping you could talk to us a little bit about oral arguments we heard very recently in two cases that involved a ministerial exception. Perhaps you could sort of walk us through the basic issue here. And even though these weren't really spotlighted as women's issues or LGBTQ issues, talk to us about the intersection there, because even just looking at the two cases before the court, it seems pretty clear that there is some rather invidious discrimination going on here.
Absolutely. And I'd love to just add on to what Rodrigo said. In my hat as a board member for the Transgender Law Center, I wanted to just let everyone know about the trans agenda and sort of putting forward an agenda that really centralizes racial justice and disability justice and economic justice. And Transgender Law Center is doing some really incredible work to lift up those voices in that work. So I want to definitely give them a shout out. Looping back to the ministerial exception cases, these are a doozy because this is a doctrine that says that if you're a religiously affiliated employer and you say that one of your workers is a minister, you get a blank check. You don't have to worry about any civil rights, any of their civil rights in terms of the cases that were, and before the court had to do with disability, and the other one had to do with age discrimination. And these were elementary school teachers at religious high schools who taught religion as one of the subjects. So they basically were fourth grade teachers, fifth grade teachers, but because they taught religion as one of the many subjects they covered, they were excluded from civil rights protections. That's the argument of the schools. And the implications for this are just incredibly broad in this moment of this pandemic for healthcare workers. So many healthcare workers work at religiously affiliated hospitals. And even during the argument, when the other side was asked about that, he said, well, if a nurse takes care of a sick patient and also prays with the patient, maybe she would be a minister and she wouldn't have her civil rights, which was just unbelievable. The same goes for camp counselors. What if you're a football coach, but you do a prayer with the team? So there's really no end to what religious employers could do with this doctrine if it's expanded. And so we, National Women's Law Center led a brief on that as well with Leadership Conference on Civil and Human Rights to say these workers' rights cannot be tossed aside. These folks are not ministers. Religion is not the core element of anything that they're doing. And again, go with the precedent. The precedent is there was a teacher who was a commissioned minister and a teacher who didn't get her civil rights. That doesn't mean anyone who teaches religion at a school, at a religiously affiliated school, should be denied her civil rights. So there is a lot at stake here for workers' rights, and that includes women, that includes LGBTQ individuals, and really all of us. So we've got to keep watching for that decision as well.
Yeah, thank you. I have to say, I'm very frightened by these cases at this court. Linda Greenhouse of the New York Times recently wrote a wonderful column about the sort of dueling narratives here, and how one of these cases involves a woman who was essentially fired because she had breast cancer and told her school that she had breast cancer, and the school fired her because allegedly it did not want to cover the costs, and now is using this religious exemption as a shield. And it seemed to me that the conservative justices didn't really see that narrative. They just saw a story about a wonderful Catholic school that wanted to raise a new generation in the faith and wanted to make sure that it could choose its own religious leaders. And of course, framed that way, who could disagree? And it's very easy for the actual individuals behind these cases to get lost in all of the legalisms. So thank you for talking to us about those cases. While I am on the panic train, I'd like to turn to Sharon and talk about another impending case that's making me very anxious, and that's Fulton versus Philadelphia. And this is a case in which a Catholic social services agency had its contract terminated with the city of Philadelphia because it refused to screen same-sex couples as potential foster parents. And now the agency is suing, alleging that Philadelphia somehow violated the First Amendment in terminating its contract. Sharon, could you talk to us a little bit about that case and its potential ramifications?
Absolutely. And in many ways, there's really just a through line here where we see religious entities, being more and more aggressive with their arguments, reading, sort of what they think is the direction of the courts, not just the Supreme Court, but it's important for us, obviously, to recognize that Mitch McConnell brought the Senate back, violating all kinds of public health and social distancing norms to put more of his judges onto the bench for the rest of their life. And the narrative here is that, not that we want to make sure that we necessarily get to play by the same rules as everybody else, which used to be sort of the narrative, right? You have to treat us the same. No, in Fulton and in other places, and in many ways, these ministerial exception cases are very similar. We want you to not only allow us to play in the pool that everybody else does, but then we want an opt out of the rules we don't like. And that's exactly what's going on with the Philadelphia case, right? You have a Catholic, child services provider that is demanding the right to contract with the government while demanding the right to not follow the non-discrimination rules that are designed to ensure that every child that is in that system has their welfare placed ahead of any particular sort of ideological agenda. We have another case that's very similar that is sort of working its way through the courts right now in South Carolina, where you have a child welfare agency called Miracle Hill, basically the biggest game in town, and they refused to abide by the federal guidance, the non-discrimination guidance, and proceeded to sort of basically get their governor to go to HHS to give them a waiver so that they could continue to get federal taxpayer dollars, but then have a religious litmus test that basically said, unless you can check the boxes of our particular brand of evangelical Christianity, which by definition in their world excludes gay couples, we want to be able to close the door in your face. And so it's important to sort of think about all of these things together, right? There is really not just a desire for religious entities to sort of be able to sort of be, and that's always that narrative. We want to be able to provide our services the same way as everybody else, and it's discriminatory to not let us in when we provide all this good. No, they want to be able to operate with federal taxpayer dollars operating by their own rules, right? And obviously, this is a court that is going to be much more receptive to those arguments than courts in the past. I'm not necessarily sure that they've got the 5 votes, either in the ministerial exception cases or in the Fulton case. But again, it's another place to remember that if this were just about following the law, decades of case law are on our side on this. This should be a slam dunk. But what we have is a radical attempt to re-envision the law with who is being put on the court. And so that's why we see arguments being made again and again that would never have passed the laugh test, that are now actually surviving, motions to dismiss and moving now on to the Supreme Court. And again, I wanted to sort of draw those connections to the same way that we're seeing, the abortion opponents go again and again, passing laws again and again that they know are unconstitutional or were unconstitutional, right? There's no difference between the Louisiana law and the Texas law. The only difference is who's on the Supreme Court. And in Idaho, it's really important to note that the law that was passed in Idaho is in blatant violation of a federal court victory that we won 2 years ago, and they don't care. They don't care. They are completely lawless in their desire to go after women's rights, trans rights, LGBT rights, the rights of those that they consider to be vulnerable or not part of the world that they are trying to create. And so that is how sort of all of this plays together, not only in terms of the advocacy that's happening in the court, but it also needs to be happening in our communities. And it also needs to be happening when we think about the census, when we think about voting rights. All of this has to be understood. We can't beat this back with just one tool, because they're coming at us with all of them, and we need to be fighting with all of those tools at the same time.
Well, yes, snaps for Sharon. Thank you. That is very rousing. There's one last point I'd like to hit before we end tonight, which is marriage equality, which is, of course, a settled issue to some degree. It was settled in 2015, but like you said, Sharon, there are different justices on the court now. And earlier this year, the Seventh Circuit Court of Appeals issued a decision compelling Indiana to provide accurate birth certificates to same-sex female couples who are married and who have children. Indiana was fighting that, was trying to deny equal rights to lesbian couples, essentially. It doesn't look like the state's going to appeal that decision, but anyone who'd like to speak to this, how worried are you about marriage equality at the High Court? There are cases like the birth certificate case that could bubble up. How worried are you that Justice Kavanaugh will turn around and sort of destroy Justice Kennedy's legacy and either cut back on or overturn marriage equality? Everyone gets 20 seconds. Jay, you start.
It always worries me that there's been some efforts to try to undercut the Obergefell decision, and you have opponents arguing that that decision was only about the right to marry and not all the attendant benefits that are associated with marriage. So I think we're going to still continue to see efforts to do that. How it will, what will happen if a case goes up to the Supreme Court? I hope it won't come to that. But.
Sharon.
Well, we were just in federal court in Georgia. Is today Tuesday? Is it only Tuesday? This morning, actually, fighting over whether or not the State Department could refuse to recognize the child born of a married same-sex couple abroad by imposing their own sort of fabricated definitions about biological connections that need to happen between parents and children. So we know, in the same way that these arguments about sort of biological differences between men and women and boys and girls are being deployed to try and take rights away from trans people and from many other people by extension, we know that we're going to see, the opponents continue to find whatever arguments, even if they're not actually grounded in fact, because by the way, like there are lots of different ways that parents, create families, and by the way, different sex couples use assisted reproduction technology as well. And we're not asking them to sort of produce their medical file before we recognize the marital presumption that creates a bond with children. So I do think we're going to continue to see, this grasping at straws. I don't know that we'll see sort of a full, attempt to repeal marriage equality. I think that is something that is probably sort of more, beyond the pale, but I think what we'll do is we'll see, these ways of trying to parse out different rights within marriage, and thus far we've been able to sort of beat that back. And then again, we'll obviously sort of see the continued sort of line of cases of, well, that's fine, the state has to marry you, but anybody else out in the world who's operating a business, can decide to pick and choose whether or not they want to actually sort of treat you as an equal citizen. And, we're going to continue to have those cases as well, being pursued very aggressively by opponents of civil rights.
Sunu?
Yeah, so the case that is coming to mind is one where an employer tried to argue that they don't have to give health insurance to the spouse of someone. And it's sort of like, it just highlights, one, all the problems of having these rights connected to one marriage or to a job, right? In this moment where everyone needs health care, and having it like artificially tied to these other things doesn't make sense. But marriage does give you all these rights, and we have to keep pushing for all of those benefits to accrue in the ways that were meant. It can't just be sort of a symbolic right to have a party. That was not what was at stake.
And Rodrigo, you have the last word.
Yeah, I think we're past the point of our opposition going after marriage equality on its face, but I think they're never going to stop trying to find every angle they can to insert themselves into the public conversation about LGBT people and our own humanity. I think schools is going to be an area where we're going to see even more attacks. Tomorrow, Gavin Grimm's case is going to have an oral argument. Gavin Grimm's case, a lot of people may have heard of it a few years ago, and it can feel like it's old news, but that case is still kicking around. And this is about a transgender high schooler. He's not in high school anymore because it's been that long, but when he was in high school and his school was trying to protect him and it was met with backlash and they did terrible things, and just it's an example of the opposition really weaponizing our young people, really taking advantage of the youngest and most vulnerable people in our community and going after public schools, which they see as a site of interaction where different kinds of people come together, and trying to weaponize that against us. We saw that in state legislatures too, with multiple states, over a dozen, floating different kinds of bills that all undermined transgender students' ability to participate in sports as the people who they authentically are. So I'm not worried about marriage equality, thankfully, anymore these days, but I think schools and youth are going to be attacked a lot by our opposition.
All right. Well, thank you so much, Rodrigo. And thank you so much to all of our panelists. This has been a very fruitful discussion. I'm actually a little calmer now than I was at the beginning. You might just be soothing presences, but I feel a little gleam of optimism. So thank you for that. And now we're going to turn to Julia Peter, who is the Director of Innovations Management at the Center for Popular Democracy. Julia is responsible for creating and managing programs that bring individuals into high impact, direct action, and large marquee campaigns. Welcome, Julia.
Thank you so much. Hi, everyone. Thank you to Representative Nadler, Mark, the panelists, and Demand Justice for this very important conversation. Listening, it really brought me back to October and being out front of the Supreme Court with so many of you during the oral arguments, scrolling through the attendee list, and I just see so many familiar names who are outside with us, and I just want to give you a huge shout out. CPD was so glad to show support to the organizations who organize that civil disobedience, which includes Housing Works, Vocal New York, Health Gap, ACT UP, and AIDS Now, DC Dyke March. I can't name them all. There were so many groups, and we were just so happy to be able to be there and support that day. Over 100 individuals were arrested that day in action in front of the Supreme Court. So many people spent hours on buses to get to DC. You all slept on church floors. Some of you spent the night out in the rain out front the night before to hold space for us in the morning. So just want to say a huge thank you to all of you. And if you remember, a lot of you were there for several days because a couple days prior, CPD, Demand Justice, and the Women's March took action and rallied outside the Supreme Court for the 1-year anniversary of Kavanaugh's swearing in, which really just brings me to my first point, my first ask of you tonight. Remember all of this in November, who brought us here and who brought us to this moment, a moment where in just one term, the Supreme Court rule on cases impacting immigration, the environment, as we've heard tonight, LGBTQ plus community, reproductive rights, the disclosure of Trump's tax cases, Native sovereignty, the CFPB, our elections, criminal legal system, Puerto Rico's economy, and so much more. All of these cases could have wide-reaching consequences. So take these fights with you as we work towards and organize towards November. Second, I'll just ask you to join our future roundtables. Tonight was the 4th in a series. We'll be back again Monday at 8 talking about the Consumer Financial Bureau protection cases. Third, I will ask you to tell your story with us tonight through the magic of Zoom. In a few minutes, a link should pop up, and it'll be a very easy process, just through a few clicks and some typing to share the story about why this case matters to you. And then finally, contact your senators. We heard a lot tonight about the Equality Act. Please go to congress.gov, see if your senators are on it. Either way, you're going to call them and tell them to get on it if they're not. If they are, call them and thank them and ask them to take it a step further and be a champion and see this, through to the finish line. So those are my 4 asks for you tonight. I look forward to continuing this discussion with you next week and also continuing in action with you all. Thank you.